Hey there. Thanks for tuning into the Freedom Update. Today I want to tell you about a new court decision about federal quarantine hotels in Canada, and I also want to talk to you about an exciting decision from the Ontario court related to the power of the government to seize and dispose of private property. If you're new here, welcome. My name is Christine, and I'm the litigation director for the Canadian Constitution Foundation, which is a legal charity that works on issues of fundamental freedoms in Canada. I upload videos about developments on our ongoing cases, we have a lot of them, and also about interesting constitutional developments from across Canada and about how you can get involved in fighting for a freer Canada. If that sounds like something you'd be interested in, please hit the subscribe button below and like this video. It really helps us out. Okay, I know a lot of you really want to hear about our federal quarantine hotel case, which a lot of you have been following along, but for those of you who haven't, let me give you some background. Earlier this year, the Canadian government created a requirement that all incoming travelers into Canada need to get a COVID test before they can board a plane, and then they need to get another second test when their plane lands. While they wait for the result of that second test, they're required to quarantine in a government-approved hotel, and they are required to pay the cost of that hotel, which runs around $2,000 per traveler. You stay until you get the result of the test, which is usually 1 to 3 days, although you don't get a refund if your test comes back earlier. This rule has created a really significant burden for a lot of travelers. For example, people who need to leave Canada to attend to a sick loved one overseas, to go to a funeral, to arrange end-of-life care, or for people who might have a spouse who lives in another country. I spoke to hundreds of Canadians and was actually contacted by thousands of people who were in situations like that. And we decided to work with 5 applicants who all needed to travel out of Canada and return for compassionate reasons and who couldn't afford these quarantine hotels. As a result of our legal challenge, the federal government actually did change the rule, which was good news. They created an exemption for compassionate travelers who needed to leave Canada for compassionate reason. There was already an exemption if you needed to enter Canada for a compassionate reason, but our advocacy did result in the creation of an exemption for people who needed to leave Canada for those reasons. That exemption did end up helping some of the applicants in our case. For example, there was one man who needed to leave Canada for his wife who lived in the United States who was having surgery. There's another applicant who needed to leave Canada to attend to end-of-life care for his mother who lives overseas. But we did have some applicants who needed to leave Canada for funerals, and unfortunately, the rule didn't help them in time. The rule change didn't help them in time, but it will help hundreds of other travelers who are in similar situations. So that was a good development as a result of our case. I'd also like to comment briefly on some of the absurdities around the quarantine hotel rules. For a long time, there was no exemption for travelers who are vaccinated, even though all the data suggest that it's incredibly hard to contract, let alone transmit COVID if you're fully vaccinated. Another absurdity is that if you're in a quarantine hotel and you test positive, the government response to that situation is usually to just send you to quarantine at home, which sort of begs the question of what was the point of the hotel to begin with? What was the point of all of this? Oh, and don't forget that the quarantine hotel rule only applies to people who fly into Canada and who fly into large airports in Toronto, Montreal, Vancouver, or Calgary. If you drive into Canada, you don't need to go to a quarantine hotel. And while all travelers are supposed to fly into those 4 large international airports, hundreds of private planes have actually been landing in smaller airports across Canada that don't have quarantine hotels. So some of these absurdities actually led to a federal advisory committee giving a recommendation to the government to end mandatory quarantine hotels. So the government has ended the requirement for fully vaccinated travelers, but I would say there are still some absurdities that exist. So a lot of the rules still just don't really make sense. Okay, so let's get to the result of our case. The case was heard at Ontario Superior Court on June 28th, and we argued that the quarantine hotel policy was a violation of the charter-protected right to mobility, that's to enter, remain in, and leave Canada. It was a violation of the right not to be arbitrarily detained, a violation of the right to liberty, and a violation of the right against cruel and unusual punishment. The treatment of many of the travelers in these hotels, especially at the beginning, was really quite horrible. For example, we included evidence in our case from a man who has diabetes and who wasn't provided any food for nearly 24 hours, which can actually be really dangerous for a person with diabetes. We also included evidence from a family who had just returned from Lithuania to adopt a baby. And this was a two-year-old toddler who'd been raised in an institution, and he had to spend his first few days in Canada in one of these government-mandated facilities that couldn't meet the needs of a small child who was going through a really frightening transition. That evidence to me was just incredibly heartbreaking about this family who couldn't provide adequate food for this child, who didn't have a way of keeping a young child in a frightening situation, entertained for long periods of time. It was just really heartbreaking. Unfortunately, the court did not find in our favor. The court largely adopted reasons from another case brought by a different group of organizations. Even though that case had different applicants, different facts, and different arguments, the court adopted those reasons for the most part. We're now considering our appeal options because we think this was a wrong decision. It was obviously not the decision that we wanted. But I will say that our advocacy did have a positive outcome because it did result in a change to the rules for compassionate travelers. And while we shouldn't have to take the government to court in order for our applicants to have received a common sense exemption for compassionate travel, I am pleased that our work did result in a change in the rules and made a difference for a lot of travelers. If you are interested in learning more about the next steps in this case, I've put a link in the description box below about how you can stay updated about all things quarantine hotels because they're not over yet for a lot of people. Okay, now, so while that was a little bit of some bad news about that case that we didn't win, it has been really, really busy here at the Canadian Constitution Foundation with lots of cases going on. And this week we actually got a bad decision, but we also got a good decision. We're involved in this really crazy case called Norwood Estate, and we got the decision in it this week, and we're really happy with the outcome in that case. That case is about something called civil forfeiture. You might not all have heard of that. It's a process where police and ultimately the government take assets from people suspected of involvement in crimes or illegal activities without necessarily charging that person or the owner of the property with any wrongdoing. The problem with civil forfeiture is it can actually entangle a lot of innocent people who are never suspected of or even accused of a crime and result in their property being seized by the police and forfeited to the government. The seized assets are then generally sold by the government, and the money can be used then to fund police operations, which creates a network of really bad incentives. The case that we were involved in has some pretty spicy facts, and we were mostly involved arguing about a legal principle rather than the parties in this particular case. But since I know you guys like spicy facts, I'll give you the background of the case. Michael Norwood was charged and awaiting trial for some criminal drug-related offenses that came out of a really large drug investigation in the Ottawa area. The investigation actually resulted in the arrest of 29 people, including some Hells Angels and some correctional officers as well. Now, Mr. Norwood, he owned a home in the Ottawa area, and he also owned an Ottawa strip club called the Silver Dollar, and they were both seized by the federal government and sold while he was awaiting trial. But before his trial could take place, he actually passed away. This stopped the charges against him, and the federal government, who had seized the assets, decided to end the forfeiture proceedings. Then the provincial government decided to step in and initiate a civil forfeiture proceeding. The previous forfeiture was a criminal forfeiture. This was a civil forfeiture, which has a lower civil standard. The government just needs to show on a balance of probabilities that the properties are tainted by crime. But instead of proceeding with the civil forfeiture, even on this lower civil standard, the government decided to sort of sidestep their own legislation and give away some of the proceeds of that sale of the home to Mr. Norwood's mother. Michael Norwood's mother claimed that she had a partial interest in the home dating back to the 90s when she had given him some money to do some renovations. She claimed her interest was worth about $138,000, and the government decided to just give her the money, even though the estate itself was disputing both her interest in that money and in the forfeiture. This basically denied the estate the right to defend against the forfeiture proceedings by giving away the assets. This was all done before there was any finding of whether the assets were actually tainted by crime. So think about it this way. If the forfeiture had proceeded and the estate was successful and they showed that there was no tainting of crime and these were just regular assets, the estate should have been entitled to keep them. But by that point, the government would have already given the assets away. This isn't how the legislation is supposed to work, but the government was saying it is. So sort of think of it this way. You and your brother are in a fight about who owns the family car. You say it's yours, your brother says it's his, and you haven't settled this, you're trying to work it out. Then your brother lends the car to his kind of bum friend, and the friend uses the car to start selling drugs. The police seize the car, and instead of doing an assessment of whether that car is actually tainted by crime, they just kind of say, oh, it's your brother's. You are in a dispute with your brother about who owns the car. So this is not how the legislation is supposed to work. That is what we were in court arguing about how this law needs to be interpreted. Even if the person has a really compelling story, which, maybe Michael Norwood's mother did have a compelling story, but the government still has to show that the assets are proceeds of crime. They need to follow their own rules if they're going to take people's property. You'd think that this is common sense. I mean, the purpose of civil forfeiture laws is to deal with proceeds of crime, so they should be required to show those assets actually are proceeds of crime. The government can't just go around giving away other people's property, but that was essentially what the government was arguing they had the power to do in this case. And that was what was so concerning to me and to the Canadian Constitution Foundation. It shows how far the government really is willing to go to expand their power to seize private property. So the exciting news in this case is that the Ontario Court of Appeal agreed with our position, and they found that the government can't just pay out money from something that the police has seized as an asset until there's actually been a determination by a court that that asset is proceeds of crime. And that's a really important clarification in the law, and it's why we participated in the case. Okay, so normally I'd give you guys an update about some other interesting cases from across country that I've been reading about, but those were two really big updates, so I'm just going to leave it there. But if you want to learn more about some of the other stuff that we're working on, visit our website, which I've linked in the description below, and check out our newest campaign, which deals with domestic vaccine passports, which restrict travel between provinces. I support vaccination. I'm vaccinated against COVID myself, but I think that these policies are a problem because they go against the notion that Canada is just one country. So check it out and please sign our petition linked below. That's all for this update. Thanks for tuning in, and let's keep fighting for freedom in Canada.